chairs are back in place. Any matters that we need to take up?
Your Honor, I will just tell the court that as instructed during the break, I spoke to the SBI in an effort to determine if any of those handwritten notes exist. They have informed me that they do not. I've told Mr. Bradsher that a moment ago. The only other thing, and I don't know that we need to discuss it or bring it up, but I got it during lunch, so I will bring it up, is that I received a notice from the Court of Appeals on the stay. It was the order denying the stay in the matter. I did not bring that with me. I assumed there would be one in the court file, but because it had been mentioned earlier in the proceedings, I bring it up that I received that notice today, and we had not mentioned it today.
Okay, that's fine. I hadn't seen it yet, but we'll take note of that, and I expect that we'll either be provided a copy or we'll be able to find it on their website.
If not, I can retrieve mine this afternoon.
It's fine. All right. And Mr. Bradsher, anything?
No, Your Honor.
All right. The bailiff received a note from one of the jurors who had sort of a question, a substantive question about for Mr. Mays, and I'm going to just explain that although in some states jurors are invited to give questions to witnesses, in North Carolina that's not the case, that they should listen to all the evidence, and that at the conclusion of the matter during their deliberation they'll be given some instructions on how they can make inquiries of the court, but that generally they should just simply listen carefully to all the evidence as it comes in. All right. Okay, let's bring the jurors in, please.
Yes, Your Honor.
And Mr. Latour, if you have any cooperating co-defendants in this case testifying, if you'd give me a heads up so I can do a brief inquiry before we call them as witnesses. I just want to make sure that I do that outside the presence of the jury.
Yes, Your Honor.
Very good. Thank you. Welcome back, ladies and gentlemen. Let's see, before we get started, I got a note from one juror asking sort of a follow-up evidentiary question. And I'll just say, although in some states jurors are invited to ask questions of witnesses, in North Carolina that's not the tradition. So you're just simply invited to listen to the evidence carefully. There is a process when you get to the point of deliberation, and I'll give you instructions on that prior to your deliberations. There's a process where you can make inquiries of the court during your deliberations, but beyond that, substantive questions about evidence are really not received from the jury during the course of the trial. And of course, if you have questions about you need a break or any other concern that comes to mind, you're certainly free to give notes like that to the bailiff, but I just wanted to clarify that one issue. All right, very good. Let's go ahead and ask the state, will there be further evidence from the state?
Yes, Your Honor. At this time, Your Honor, the state would call Margaret Wiggins.
And if you would, please place your left hand on the Bible and raise your right. If you solemnly swear the testimony you give before this court to be the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you.
Mr. Latour?
Thank you, Your Honor. Ms. Wiggins, just make yourself comfortable. You've got a microphone there, so if you'll just speak into that so that the jury can hear you, okay?
Okay.
Will you please state your name for the court?
Margaret Blandon Wiggins.
And Ms. Wiggins, are you currently employed?
No.
And are you retired?
Yes.
How long have you been retired?
Since January 1, 2016.
And where did you retire from?
The Administrative Office of the Courts.
And we commonly refer to that as AOC.
Yes.
What is AOC and what is their role?
We handle the administrative functions of the judicial department, of the judicial branch of government, financial, human resources, purchasing, all of those types of matters.
Okay, when you say the judicial branch, what are you referring to?
All 100 counties, all clerks of courts, all Superior Court, District Court judges, Supreme Court, Court of Appeals, public defenders, district attorneys, magistrates, and a few others.
So if a district attorney, by chance, has a money issue, is the administrative office of the courts where they would go to resolve that issue?
Yes.
Okay. And while you were at the Administrative Office of the Courts, how long did you work there?
About 25 years.
What was your role at AOC?
My departing role was Human Resources Officer. Prior to that, I was hired originally as the Compensation Manager, and then I was promoted to HR Officer.
Okay, how long were you in the HR department?
I think 2007.
Okay. And what would have been your job duties when you were in your last role at AOC?
We had a staff of about 22 people in the Human Resources Department, and we were responsible for all hiring processes, firing processes, transfers, everything dealing with salaries, all of the benefits, employee relations, health and safety, training. That's about it.
Pretty much everything.
Yeah.
Okay. While you were employed in doing that for the Administrative Office of the Courts, what role did you have in communicating with district attorneys' offices?
It was somewhat limited. In a way, I was kind of the person that they came to if they couldn't get the usual things. So they had a special hiring or something that was outside the norm. I would be the one that would come to. And some DAs would just contact me for everything, and then I would, pass it on to the appropriate person to process.
When they would contact you about those sorts of things, like you specifically mentioned, a hiring outside of the norm, what would your role in that be?
Well, I would check into the matter I would always check our policy manual, check the legal statutes, and if I couldn't find it there, I would go to our legal counsel for help.
Are you an attorney?
No.
Okay. What type of background did you have that led you to working for that branch of the government?
Well, I started out in Louisiana in human resources, and I was a manager there, and then I was hired at the Office of State Personnel as the compensation manager there, and while there I was offered a position with the AOC as compensation manager there.
Okay. When you say this about receiving requests or inquiries about special hiring, would you also have to, if you guys at AOC located or noticed some anomaly or something out of the ordinary, would you be one of the people that would reach out to those hiring officials to alert them of it?
Yes, most often. Sometimes the salary administration specialist might do that, and if there were an issue, I would do it. Either one.
Okay. And did you have a role with the elected district attorneys as far as training goes and having them come to AOC for anything?
Yes, Peg Dorr is the executive director, or was at the time, of the district attorneys, and she was primarily responsible, but she would invite me to give maybe 45 minutes or an hour orientation on human resources to new district attorneys. It was never enough time, of course.
Okay. You say there's never enough time. Why is that?
There's a lot to cover.
Okay. There's a lot to cover and a little bit of time to cover it all in.
Correct.
So given that constraint, are you able to cover every topic?
Absolutely not.
And in doing so, do you kind of do you have to make decisions about what you cover and what you don't cover?
Sometimes Peg would kind of give us direction on what she wanted us to cover.
Do you recall if you ever, and specifically in 2014, spoke to a group of elected district attorneys about HR-related topics?
I did.
Okay. And during the course of that discussion, do you recall if you mentioned anything to those group of people about employing spouses or relatives?
I apparently did not.
You don't know if you did or you didn't.
I don't recall, but no,
Okay.
I don't recall.
Having gone through that and provided this topic of conversation with those DAs, did you at some point determine, or were you alerted that there was an issue about some folks hiring related people?
Yes. One of the things I did cover at the conference and probably followed up was that when new DAs come on board, frequently there are some employee changes in the office resulting from that. And so we were trying to explain that if there are going to be some employee changes, we need to know that right away. So send me a list of all the people that were staying and the people that were leaving so that I could send them a proper hiring authority package, which would include all the forms and everything they needed to do to properly post the position for competitive employment and the salaries and all that kind of thing involved. So that was one of the things I did. And they were following up with me, and I would be following up with them on, making sure we got that information before January 1st.
Okay. Did you receive a fair amount of inquiries about changes in staff within offices?
Yes, and sometimes those things would come directly to the salary. I had a salary administration person that was assigned to each county, each district, and so sometimes they would communicate more directly with them, but sometimes it came directly to me.
When you say each district or each county, what are there things like prosecutorial districts?
Yeah.
Okay. And are those necessarily by county?
Well, no, they're not, but a district could have one county, like Wake County has one, District 10, and then other counties might have 2 or 3, 4, 5, 6, 7.
Okay. So there could be multiple counties within a district, but those districts would have one elected official?
Right.
Okay. One elected DA to run those
Correct.
counties? Okay. And so you would have a salary person assigned to each of the districts?
Yes.
Okay. Do you recall if you had a salary person, and if you did, who it was that was assigned to a person in Caswell County?
We definitely had someone assigned, and I believe it was Shannon Mears.
All right. And at some point after this meeting with the DAs, did you receive a list of changes from the defendant?
I did.
Okay. How did you receive that information about the list of changes?
By email.
Okay. And do you recall the date?
The 16th, December 16th, I think it was from his assistant, perhaps.
All right. Okay. And that would have been December 16th of 2014?
Yes.
All right. And when you received that list, what, if anything, did you do?
Well, I believe the list included some salary changes. And so I believe I have copies of these emails.
Okay. We'll get to the specifics of the email, but what's your recollection of what you did?
Well, the first thing I would have sent it to Shannon Mears for processing. And then, I'd follow up on anything that was weird.
Okay.
Out of the ordinary.
Okay. When you would receive these salary change requests, why are those being sent to you?
Well, we had a recession going on at the time, and the district attorneys, each district attorney would get an allotted amount of money for each position in his office. The district attorneys, the assistant DAs were allotted a certain amount by statute, and the victim witness legal assistant positions were allotted a certain amount by policy in the AOC. And the same with the investigators and the administrative assistants. And during this recession time, the director of AOC, in conjunction with the district attorney conference, had lowered the amount of money that they were going to get in some positions. And so I had another person on my staff, Kurt Miller, who was responsible for overseeing the financial end of every salary change. So number one, we had any salary change we had to make sure they had enough money in their budget. And they basically had two budgets, one for assistant district attorneys, and the other budget was for the support staff. That would be victim witness, legal assistants, investigators, and the administrative assistants. And so he would make sure that they had enough money in either or budget to cover. And also we had a restriction on salaries. In fact, the legislature had a restriction on salary of 10%. You couldn't give anyone an increase of over 10% without supporting justification. So the Judge Smith was the person who would have to approve any increases over 10%. So in some salaries, when they came in, they had to fill out a form, explain why, and then we had to make sure they had enough money, and then we had to, run it past him, because we were afraid we were going to have to answer to the legislature. If we had a lot of people getting paid over 10%, they might, the legislature can be.
Okay. So if I'm understanding you, to talk about the allocations of funds, are you saying essentially that there are two pots of money that are given to each elected DA?
Right.
And there are so many slots, meaning so many assistant DAs are allowed to exist in that county.
By the legislature.
And that's created by the legislature. And there's a pot of money.
Correct.
And it's kind of divided up by each DA slot is assigned a certain amount of money, and all of those monies get added together in one pot.
Well, sort of. They're actually, I think, separate funds, so we tried to keep them separate. We did keep them separate.
Okay. And then there's another victim witness legal assistant investigator group.
Yes.
That has slots assigned or allocated number of slots with a pot of money for those.
And in addition to that, there are minimums and maximum salaries that of the support staff can be paid. There's a minimum salary for assistant DAs, but not a maximum.
Okay. And so these two pots of money, when someone wanted to change, particularly over a 10% raise for a position, it had to come through AOC so that you could just kind of do the math and make sure everything is on the up and up as far as you've got enough money to cover it. And a justification has to be provided if there's a raise over a certain amount of time during this time frame.
Yes.
Okay. And did you receive a list of salary changes from the defendant?
Yes.
Okay. And were there any of those that caught your eye and made you look twice at them under the criteria that you just mentioned?
Yes, there were those that were over 10%.
All right. And when you received that email, was that an email form that you got those proposed salary changes?
Yes.
Once you received that from the defendant, what did you do?
Well, we contacted him back. We sent an email back to him with further instructions on what needed to be done, the justification, because I told him I'd have to get approval. And then I asked about one particular employee that had the same last name as he did.
Why did you ask about that one particular employee?
Because my Shannon Mears had brought it to my attention that she said, I think they may be related. And she said, I think maybe this has been going on a while.
And had it in, were you able to determine if they were related?
Yes, she verified that.
Okay, and it had been going on for a while.
Right.
And had AOC known about it or caught it?
Well, I guess not.
Okay.
I guess not. We didn't know.
Okay. Does it appear that they were trying to hide the fact that his wife was working there?
No.
Just same last name as all you had, slip through the cracks sort of deal?
Right. Well, we have a policy. I mean, the policy that was in place at the time said basically you shouldn't do this.
When you say we had a policy, who had a
The
policy?
Administrative Office of the Courts had a policy that was actually put in place by, I think, one of the Chief Justices at some point in time. So it's one that we always adhered to, that highly recommended that you never have someone on staff that is related to you, particularly that reports to you. However, because they were elected officials, we couldn't really enforce it. It wasn't an enforceable policy. What happened was that the Ethics Commission had a law that we found out about. I know I went to training, our legal counsel organized training for them to come out. And all of the top people I was also subject to the state ethics. I had every year had to fill out the form that you have to fill out. And there were 5 or 6 of us that the Chief Justice had placed in that same status, as are all of the other elected officials. And so,
Including district attorneys?
yes.
Okay.
And so this person from the state ethics came out to give us a full day of training into the very details of it. And I remember distinctly when she mentioned the part about, elected officials cannot have direct, it's by law. And I went, oh my goodness, this is a big deal. So from that point on, we tried to be very observant, and I tried to tell the staff to be on the lookout for anything like that. We hadn't put it in the manual yet, the hiring manual yet, but we were in the process. So we would become aware of it, and we're trying to
Alert people?
Yes.
Okay. Now, had that meeting occurred before or after you had given that talk to the DAs?
It occurred before.
Okay. Are you aware if there are forms or things that have to be filled out by district attorneys and elected officials with the Ethics Commission about the rules for the Ethics Commission?
You mean like the form I had to fill out every year?
Sure.
I think they all have to fill it out. I had to fill it out by a certain date.
Okay. And do you recall what the contents of that form that you had to fill out were?
Oh gosh, it was like a 1040.
Okay.
It was very detailed on income and assets and who lives in your home and, all kind of things like that.
Now, you're not, or are you, when we're talking about the defendant hiring his wife, are you saying that you guys were, or that they were attempting to hide this from you in any way at that point?
I don't think so.
Okay. And at some point, when you received this information from the defendant that he's, 1, got his wife employed by him, and 2, attempting to give her a salary change, you say you reached back out to the defendant.
Right, and in my first communication, I mentioned our policy about it, and that was on, I think, December 17th when I responded back that, just cautioning to look at the policy, that we don't recommend hiring the wife, and that we were aware that the wife had been hired since 2011. It was later that it dawned on me that, oh, this is a bigger deal. This is the Ethics Act, so.
Okay. Now, you say that there was the provision in AOC's policy that was essentially unenforceable for you guys, correct?
That's the way I felt about it.
Okay. But the Ethics Act is not?
Correct.
Okay. And that's something separate, that's a separate actual law, not
Yes.
just a policy?
Correct.
Okay. When you realize you have this epiphany moment that this is a bigger deal, as you put it, what did you do at that point?
Well, I confirmed I feel certain I confirmed it with the legal counsel. I usually did in those matters, but immediately I sent an email, composed an email to Mr. Bradsher, about the problem.
Okay. And did you reference the Ethics Act in that?
I did.
Do you recall having any conversations with the defendant about this situation other than these emails?
I believe I first sent the email on a Thursday, January 8th, to both Mr. Bradsher and Mr. Blitzer. And then it was Monday morning, I think I got an email from Mr. Bradsher saying he wanted to talk to me, that he apparently had some communication with the Ethics Commission. So yes, we had a phone call, I think, based on those emails.
Did you at some point bring up this idea to the defendant about a quote-unquote waiver of the Ethics Act?
I did. I stated that, and by that I meant the Ethics Act states that you can appeal a decision to a board, which in my usage of terms didn't be a waiver.
Okay. So are you aware that there is such a thing as, if there is such a thing as an actual waiver of that?
Well,
Or is what you were suggesting that a board may find that it's not a violation of the Ethics Act?
correct. I didn't really think they would, but you never know.
You didn't think they would what?
Think it okay.
Okay. But you suggested it, why then?
Just because I wanted Mr. Bradsher to understand, and Mr. Blitzer, that, this was out of my hands. This is a law.
Okay.
And if you can call them to verify that.
Okay. You said that you sent these correspondence by email to the defendant. Did you also send similar correspondence to Craig Blitzer?
I did.
And why did you send it to Craig Blitzer too?
Well, because Ms. Mears, she discovered right away that he was hiring his wife.
Okay, when you say you discovered right away, he was a newly elected DA.
Right, and he was sending in the paperwork, and she noticed it.
Okay. And so when Ms. Mears noticed that, it was brought to your attention, so then you reach out to both the defendant, Mr. Bradsher, and Mr. Blitzer.
Correct.
Okay. And you provided similar information to both?
Yes, I did.
At some point, were you made aware of a possibility of them exchanging employment's duties for their wives?
Yes, I believe Mr. Bradsher called me that morning on the 8th, Monday the 8th. I think that's what we ended up talking about.
Okay. And do you recall the content of that conversation? And if you do, can you tell us what you guys talked about? How the conversation went?
Well, my recollection is that he said they had discussed it, and I didn't even know they were in adjoining districts. I mean, that was a surprise to me. So it was like, okay, it was different. The solution was obviously unusual, but I talked with my legal counsel, and we couldn't find any law that said they couldn't do it. In other words, we were saying, your wives are going to have to resign from their positions by the Ethics, Commission, unless they say otherwise. And then, but if they should be rehired by another district attorney, there's nothing wrong with that.
Okay. So did you tell them if it was okay for them to just transfer employees? Is that a possibility for them, or was that a possibility for them?
Well, they had the position, the wives had to resign their positions technically in their office, whether that is in writing or just, happens. And then what we did was, in the system, unless there's a break of service, an employee, when they move from one office to another in the system, it is called a transfer.
Okay. But it still necessitates that there be an actual termination or resignation and then a new hiring procedure must occur.
Yes.
You can't just say, or can you just say, you no longer work here, you now work over here, without any paperwork or actions being taken?
Correct. It'd have to be paperwork.
Okay. And would you then provide that, you or your office then provide that type of paperwork?
Yes.
What type of paperwork would be provided?
Separation form was one. Then there's I've forgotten what the forms are. I'm sorry, I rarely saw the forms.
That's okay. But you know there was a separation form?
Yes.
And then there would probably, or would there be some sort of form to indicate the higher?
Right. And yes.
I don't know what the name of that form would be,
Right.
but some form would then be required to then, for the next employer to place them
Right.
on their paperwork.
Right, because, I mean, we had forms that had to be completed and kept in the employee file.
Okay. May I approach, Your Honor?
Yes.
Ms. Wiggins, I'm going to show you what I've marked for identification purposes as State's Exhibit 1, if you will take a look at that.
Okay.
Okay. And there's a couple pages there, if you'll just look at all of them real quickly.
Okay.
Now, that's a 4-page document. Do you recognize this document?
I do.
What do you recognize it to be?
Emails from back and forth between me and Mr. Bradsher.
Okay, and how do you recognize them as the emails that you and Mr. Bradsher were communicating through?
Because it has my name there and his name there.
Okay. I know it's intuitive, but, and you've looked at the content of these conversations, and do you recall these as being the content of the conversations that you had?
Yes.
And that's the same content or topic for when you actually spoke to Mr. Bradsher on the telephone. It all kind of revolved around the same situation?
Yes.
Right. And you recognize your name and his name, and it's kind of got some email addresses and other things, right?
Correct.
And does it appear to be a fair and accurate depiction of that conversation between the two of you in email form?
Yes.
Appear that it was changed in any way?
No.
All right, thank you. This time, Your Honor, the State will move to introduce State's Exhibit 1.
Any objection?
No, sir.
Admitted.
I'm going to show you now State's Exhibit 2. If you'll kind of go through the same thing with that, I believe it's 2 pages. And after you've had a chance to look at that, if you'll tell me if you recognize it.
I do.
What do you recognize that to be?
It's my communication by email to Mr. Blitzer about, it's come to our attention that he has employed his wife Cindy in violation of the State Ethics Act.
Okay, and this is the email that you testified earlier about sending to him?
Correct.
Again, fair and accurate representation, doesn't appear to be altered or changed in any way.
No.
This time, Your Honor, the State will move to introduce State's Exhibit 2.
Any objection?
No, Your Honor.
Allowed.
Now, looking at State's Exhibit number 1, I recognize that it's an email chain, and so it kind of goes in reverse order. Is that correct?
Correct,
So we'll
yes.
start at the back instead of the front. And the first thing there, is that an email from Holly McAdams?
Yes.
And is that the email that you said you received?
Yes.
Now, the second page has an email response from you, correct?
Yes.
And it includes in there in the middle about reassignment and or decrease in salaries, and then reassignment and or increase in salaries. Is that correct?
Yes.
Now, looking at it, I see that there appears to be one that says Pam Bradsher. Is that the one that you testified about earlier as raising some questions for you?
Yes.
And when you look at that, does it give a suggestion or what the defendant was attempting to do as far as her salary goes?
She's being promoted from a victim witness legal assistant to a DA investigator with an increase of 28.2%.
Okay, and does it list the actual salary numbers?
From 37,432 to 48,000.
All right. And there's some other ones listed there as well. Some other people got raises. What's the next highest raise increase that is listed there?
For Tyler Henderson, he's a victim witness legal assistant, not getting a promotion, but getting an increase of 26.5% from 32,410 to 41,000.
All right. And the next 3, what are their increases?
Deborah Halbrook, victim witness legal assistant, getting an increase of 1%, 40,721 to 41,139. Holly McAdams, an ADA, increase in salary from 78,924 to 85,663, that's 8.5. And John Schultz, increase from 78,872 to 80,000 at 1.4%.
Okay. And there's some decreases as well, correct? What are those?
John Ramsey, reassignment from DA investigator to victim witness legal assistant, decrease in salary from 49,576 to 30,000. Edward Williford, ADA, decrease in salary from 70,322 to 42. And Luann Martin, ADA, decrease from salary of 92,080 to 86,000.
All right, thank you. Now, when you received all of that, you then respond with that next email, correct? And that's a January the 8th at 1:15 p.m.? And what's the nature of that email that you've sent?
Well, this is where I'm telling him that I recently discussed with them my concerns and cautions about employment of relatives, but I also bring out now, this is the Thursday morning, that it's come to my attention about the State Ethics Act, and that NCGS 138A-40 provides that a covered person, such as the DA, shall not cause the employment, appointment, promotion, transfer, or advancement of an extended family member, that is spouse of the DA, to a position to which the DA supervises or manages.
Now, this email that we're talking about now, is that the same basic contents as what you sent to Mr. Blitzer on January the 8th at 1:29?
It is.
You again reference the AOC policy and the general statute of 138A-40?
Correct.
And that's that ethics provision?
Yes.
All right. And you say you regret that you didn't think to inform them of it because you didn't tell them as best as you can recall, correct?
Correct.
But once you guys discovered the fact that this is going on, you've now reached out and alerted them of this possible violation, correct?
Correct.
All right. Your Honor, may I have one moment?
Yes, sir.
I have copies of State's Exhibits 1 and 2 that I would seek to publish to the jury at this point.
Yes, if you'll hand them to the bailiff. Individual copies of exhibits that have been admitted. We'll be taking these up at some later point, so if you wish to take notes about these, write in your notepads about them. Don't mark on these because we'll be collecting these from you. And Ms. Latour, did you want the jurors just take a moment to read those, or are you going to direct
If they
them?
want to take a moment to read them first, and then I'll resume my direct examination.
That's fine. So members of the jury, when you finished your review, just look up so that when I glance over, I can see that you've had a chance to read the document.
Briefly, if I may approach again, Your Honor.
Yes, sir.
Showing you again, Ms. Wiggins, State's Exhibit 1, which is that chain of emails between you and Mr. Bradsher, the defendant, correct? Now, looking at page 3 of that, just under all of the reassignments and increases in salaries, that last kind of full paragraph that begins, is Pam Bradsher a relative? Is this you again cautioning the defendant about the AOC policy as you had discussed?
Yes.
Right. And you then, appears to be what is a hyperlink there below. What is that?
It would take to our policy manual.
Okay, and that section would have been about what topic?
Employment limitations.
Okay. Then after that, you cautioning him based upon your readings of AOC's policy is that on page 2, January 8th, 1:15 p.m. email you sent, and you again here towards the bottom, there's a sentence that begins, I recommend that you consult with the State Ethics Commission. is that where you were talking about, it says a waiver, is that what you were just talking to me about, where you were saying seek an opinion from the board?
Yes,
Okay. And below that is, again, another link, and that would have taken the defendant where had he clicked on it?
to the State Ethics Act.
Which would have had this provision that you cited earlier above?
Correct.
Okay. And after you send that, you get the email from Mr. Bradsher, correct?
Yes,
And that was at, I guess, a couple of days later on that Monday
right,
in the morning, where he says he's contacted the ethics board and he needs to talk.
right.
And did you call him after that, or do you remember?
I think we had a conversation.
Okay.
I probably did call him, or he called me.
Okay, at some point you guys talked.
Right,
Okay. And then you end up sending that same day at 11:31, which is on the first page, an email to him again, correct?
yes,
And this is the one where you discuss with him the fact that Pam Bradsher should resign her office effective immediately if there's not an exemption made.
correct.
And that was your decision based upon your office's, the administrative office's review with the State Ethics Act, correct?
Correct.
Okay. And then you send him another email, and that email is again you saying what?
That we do not see an issue with Pam Bradsher resigning her position with your office and taking a position with another judicial office if one is offered.
Okay. And that's again what you were talking about, saying you looked into it, couldn't find anything wrong if they both resign and are hired by the other people, correct?
Correct.
And does that presuppose that they would be actually, or that both parties would actually have to work for that money if they are hired?
All employees are expected to work for their money.
Okay, thank you. No further questions, Your Honor.
Cross-examination, Mr. Bradsher.
Thank you. Good afternoon, Ms. Wiggins.
Aye.
First, I want to start with this general question. Would you agree that as of 2010, this issue about State Ethics Act was not in the AOC manual? Is that right?
I agree.
So when I would have taken office January 1st, 2011, that is not something that you would be alerting newly elected DAs to, that there's this State Ethics Act with this provision in it. Is that right?
Regrettably, yes.
In fact, after the January 8th email and the attempt to resolve this, could you tell the jury when the policy was updated that actually put the State Ethics Act issue in the AOC manual?
I don't recall the date, but I know it was done.
Okay, after the census?
Yes.
All right. And in fact, in some of the emails, you expressed regret because of the information issue. But at each stage, we were in communication with regards to what the state has put into evidence. Is that right?
Say that again?
Yes, with regards to the email chain, you and I were in communication,
Yes.
and you made me aware of the State Ethics Act, and then we started working to resolve it. Is that true?
Correct.
Now, I wanted to clear up the timeline. Back in December before Christmas, at the beginning of that email chain, when the allocation or reallocation of salaries came through, when Shannon Mears came to you and the issue was flagged to you about a relative, spouse, what you sent was not the State Ethics Act. It was this policy that did not recommend doing this. Is that right?
Correct.
Okay. And I will go back to December of 2010. Do you recall going to the newly elected DA's orientation at December 2nd and 3rd of 2010?
Where was that held?
In Raleigh at Conference of District Attorneys?
I'm sure I was there.
Okay. And were you aware that I asked Peg Dorr this specific question on the first day of the conference as to whether or not I could hire my wife?
No.
Were you aware that day 2, the response I got was,
Objection.
Sustain.
all right. Do you recall Peg Dorr talking to you at all on the 2nd or the 3rd about a newly elected DA hiring his wife?
I don't recall, but it doesn't mean it didn't happen.
Okay. At the time, the answer to that question would be there's no law or policy against it, but it's not recommended. Is that right?
If someone would have asked me that, that's probably what I would have said.
Okay. And then, as Mr. Latour asked you, everything that you saw over the next 4 years, there was no attempt to hide the fact that my wife was working in the DA's office. Is that correct?
That's my understanding.
Okay. So let's talk about the salary allocations for a minute. Do you recall, were you in this position in 2011?
The HR position?
Yes.
Yes.
So do you recall at the end of the first 6 months of my term that 2 victim witness legal assistant positions were eliminated from my office?
I know a lot of positions were eliminated across the state.
And Judge John Smith was the director of AOC at that time, is
Yes.
that right? And the allocation of the victim witness legal assistants would be at his discretion based on available monies that the legislature gave, is that right?
You mean the funding?
Yes.
Yes, he worked with the conference on that.
All right. Now, in this email chain, when there is the salary increase, I believe we're talking about December 17th.
Yes.
Do you recall receiving another document based on our communication on December 18th with a detailed justification for why this particular increase was being asked for this position?
You mean the salary adjustment form?
Yes.
Yes.
May I approach the witness?
Yes.
Handy was to mark as Defendant's Exhibit 2. Just take a moment and read that to yourself for a minute.
Yeah, I'm familiar with that.
Oh, you are with the, in the bottom? Okay. Well, having looked at Defendant's Exhibit 2, you recall that I set out in detail the issue of my investigator, David Ramsey, suffering a stroke?
What, we
I'm
had.
sorry, I can.
No. I mean, I have it before me. I'm just saying
Okay.
that we had a lot of issues to deal with, so I don't recall in detail other than it's in writing there.
Okay. If you have the document, could you look at it for a moment?
Okay. Okay.
So in the email chain, December 17th, where you expressed information with regards to the policy that we've already talked about, not the State Ethics Act. After that, on December 19th, you or Judge Smith would have signed an approval for the increase in the position that's set out in the email based on the further explanation given in this document that I've labeled Defendants 2.
That's right. Judge Smith did approve it.
Isn't it true that in the explanation, the document indicated the current investigator?
Objection.
Is this your explanation that you're about to ask about, or an explanation from a third party?
From her.
From her. It's overruled as to, if it's an explanation from her.
Well, may we approach?
Yes?
And he was marked as Defendants Exhibit 2.
Okay.
Can you take a look at Defendants Exhibit 2 and tell the jury what it is?
This is a salary adjustment for district attorney offices form that was required whenever you were giving an increase to an employee.
Okay, and is that a standard form used in the course of business with AOC to justify salary increases?
It was.
And did you approve this request, and does your did Judge Smith approve this based on a signature on the bottom right corner of
Yes.
these two? Okay. And you know that of your own personal knowledge, is that right?
Yes, I saw him sign it.
All right. And this Defendant's Exhibit 2 is directly related to the salary increase that the state referenced when they were talking to you, is that correct?
Yes, it is.
Move Defendants 2 and that.
No objection.
All right, it's allowed.
All right. And you have a copy of that, is that
I
right?
do.
Could you please read for the jury the explanation given in Defendant's Exhibit 2 for the requested increase?
Okay. The current investigator suffered a stroke and is unable to perform the duties of that position. However, he is requested to serve as a victim witness legal assistant with light duty consistent with his abilities. I'm restructuring the Superior Court victim witness legal assistant position and taking 40% of those duties and combining with the DA investigator duties. Mr. Bradsher will be doing all of the duties of the DA investigator plus 40% of the previously assigned Superior Court victim witness legal assistant duties. That is grand jury, indictment preparation, coordination of officers for grand jury, discovery preparation, victim interviews, etc. Our office has never really recovered from losing 40% of the victim witness legal assistant staff in 2011 because of state budget cuts. 2 victim witness legal positions were cut. Therefore, in 2011, after the cuts and based on relative volume of cases between Person and Caswell counties, I assigned 1 victim witness legal assistant Caswell County and 2 to Person County. However, Superior Court workload has increased in Caswell, for example.
Let me ask you to slow down just a bit so the court reporter can keep up. I'm sure she can, but
I'm so
may be
sorry.
taxing her. Go ahead. I'm sorry. Keep going, please.
However, okay. However, Superior Court workload has increased in Caswell. For example, we have 6 pending murder cases in Caswell, 3 of which are death penalty cases. Therefore, in order to free up more CMS Superior Court prep time for the victim witness legal assistant assigned in Caswell, I'm also restructuring the DA investigator position to include doing district court victim witness legal assistant duties in Caswell County. In summary, the increase in salary is more than justified in that Mr. Bradsher will be performing the DA investigator duties plus victim witness legal assistant duties in Person County Superior Court and the victim witness legal assistant duties in Caswell County District Court, all under the newly restructured DA investigator title.
All right. So that is a form that's regularly used for the salary adjustment, is that right?
Yes.
And if you could explain to the jury in terms of allocations, the investigator slot, is that linked to the VWLA allocations at all?
It has a separate salary range, and the duties description is different, but it is in the same budget pool.
Okay. So I'll talk for ADAs for just a second. For assistant DAs, isn't it true that for each allocation of ADAs to a district, there is a set amount by the legislature?
Correct.
And so if there are 5 slots assigned to a district, there's $70,000 for each slot. Is that right? Approximately.
Oh, yeah, I don't know the going rate, yes.
Right. That changes, but the number of ADA slots for each district is set by the legislature. Is that right?
Yes.
Okay. And then the elected DA takes that pool of money, the number of those slots times each amount, and can distribute it among the ADAs at their discretion. Is that right?
Yes, as long as the minimum is met.
All right. Do you still have the state's exhibit in front of you?
This one?
Yeah, no, the state's, okay. May I approach with you?
Yes.
You were worked in this capacity with Judge John Smith for how many years in this particular role?
Judge Smith?
Yes.
I don't remember when he came on, maybe 2010-ish?
Oh, so 2010.
I don't know.
All right.
I don't remember.
Do you recall at the time when I first took office that I had 6 ADA slots, but the legislature had frozen one?
No, but I'm not surprised.
Okay. Do you recall that later, before the end of the term, the legislature had actually eliminated that 6th allocation?
No, they eliminated a lot of positions.
All right. And with regards to the ADA salary reallocation, do you recall that being done after I had been given one less slot to allocate monies to?
Say that again?
Yes. Let me ask it this way. Do you recall Judge Smith allowing me to use that 6th allocation when I first took office because the position was just frozen, not eliminated?
He probably did.
Okay. And then after the legislature eliminated that slot, I had to reallocate among the ADAs. Do you recall that?
You would have had to have done that, yes.
Okay. So getting in that ADA reallocation of monies is not unusual from any district, is it?
Well, okay. This is ancient history in my head, you know, so.
Didn't even have to worry.
Okay, but what I recall is when, if you lost a position, and it's true, if your budget was, say, $200,000 and you lost a low-paying position and there you were with some high-paid people, then you were going to have to make some adjustments to accommodate for that. That'd be required, yes.
Okay. But the ADA pool of money was separate from the victim witness legal assistance, is that
Yes.
right? And by statute, the investigator slot had its separate salary range, is that right?
Yes.
So, I know we're getting complicated, but let me try and make it simple. So, the need for this salary increase form on Defendant's Exhibit 2 that you just read from was because the victim witness legal assistant was going to what was considered a promotion in an investigator slot, is that right?
Yes.
Okay, at that specific salary.
Well, I don't remember, I mean, this wasn't the minimum, if that's what you mean for
Okay.
investigator.
All right, but that required a form. So
Yes.
I think you read for the DA that when Pam Bradsher's salary, it was at 37 something? Mm-hmm. All right. And do you recall that she actually started at 36 in 2011?
Do I recall that?
Well, you had documents pulled up.
Oh,
I seen you
okay.
had-
Oh, let's see. Well, at the time of the request, she was making 37,432.
Okay.
Is that what you mean? Okay.
Yes. So you don't recall her starting salary being 36 in 2011?
No, but I have a document here that might show that. Her starting salary was what, 36,000?
Yes.
Yes, that's what the personal history form says.
Okay. So is it fair to say that as of December 19th, Judge Smith, Director of AOC, had approved this salary reallocation, and with regards to information to District 9A DA's office, we haven't been told about State Ethics Act yet. It's just that policy that you've mentioned about not against illegal or against policy, but not recommended.
Correct.
Okay. So then we have Christmas and we go into the new year. And then January 8th, after we have started the second term, that's when you send me the email, the concern about State Ethics Act. Is that right?
Yes.
Okay. Do you recall, without necessarily saying what Judge Smith said, do you recall talking to Judge Smith about this issue of the State Ethics Act not being in the AOC policy and this issue arising with a DA who has had his wife working with him for 4 years?
I don't recall that.
Okay. Well, let me ask you this. Pam Bradsher, as a state employee, having worked for AOC for 4 years, did you or anybody else in the chain of command give any consideration to that fact that she was now in this position of no fault of her own?
Right, that I have had to tell judges terrible things over the years. Like, we made a mistake in your salary and you owe us $20,000 now.
Right,
And I felt real bad about that.
right. Okay.
But, I mean, the law was the law, and we had to follow it and recoup the funds, even if it was our error, our mistake.
And would you say that in part, working with us and initially saying you can seek a waiver was an attempt to try and resolve this problem?
It was really my way of letting you know it's out of my hands. You're going to have, if anybody can make it happen, it would be the State Board Ethics.
Okay. And then I communicated with you that I had talked with Kathleen Edwards. And do you recall that I shared with you about the seeking an opinion from state ethics on some type of screening procedure and transferring the two spouses in the meantime?
I don't remember about the appeal effort, but that sounds reasonable. And but I do remember you telling me that you had come up with a solution.
All right. And you involved AOC counsel in that as well, didn't you?
I feel certain.
Okay. Pam Best, maybe? Okay. And didn't we get confirming emails from you that that was okay and told us how we could do it, and we did it the way AOC said it was okay to do?
Correct.
Okay. And I believe, I don't have it here today because I thought you were in Atlanta from our email exchange, but do you recall sending Emily Best an email saying they have worked out a solution and sounds good? As far as AOC was concerned, this was approved for this change. Is that right?
That's right. We sent the paperwork to Shannon Mears and to Kurt Miller to process for the change that was going to be made. Yeah.
All right. So in terms of AOC, the situation that you were concerned about was resolved.
Correct.
All right. After this incident, do you remember who would have crafted the language to put it in the AOC manual so that now everybody would know?
Mike Smith.
Okay. And you don't have any recollection of when it went into the AOC manual, is that
I
right?
do not.
Okay. All right. And let me ask you this question. I asked you about December 2nd and 3rd of 2010. I know that's a little bit unreasonable. And you answered that you didn't recall talking to Peg Dorr, but you could have with regards to that question of can a DA hire his wife?
Correct. It would, we would have fallen back to the policy, which, I mean, it's when I read it just now again, it talks about employees, when a hiring authority hires an employee of another judicial employee with a relative on staff, it doesn't, I don't think it really looks at the hiring authority themselves, and that, so that would make it even more concerning.
Right. It doesn't even talk about the hiring authority.
Right. But I mean, it would make it more concerning. But again, we couldn't enforce that.
I understand. And because of this, y'all made it clear in the manual, so newly electeds would know from then on, is that right?
That's my understanding. Yeah, Mike was the policy guy that, worked for us, so he would have written the policy.
I want to switch to a little different area now, and it is also, will be taxing on your memory, but do you remember seeing Craig Blitzer at the December 2014 newly elected orientation?
I don't recall what he looks like.
Okay. Do you recall anybody asking you at that December orientation of whether or not they could hire their wife?
I don't recall.
Okay, so it could have happened or not happened, you just don't know.
Correct.
All right. Over the, let's say from 2011 to 2015, you have any recollection about the lobbying I did to Judge Smith to try and get an additional ADA and resources for the district?
I don't recall, but I'm not surprised. Everybody was.
You're right. And do you recall anything about our request about, well, let me ask it this way. Remember any other interaction with me specifically with regards to admin or anything else during that time period?
I don't recall.
All right. And did you feel that as an elected DA, I responded to the concerns you raised and resolved it?
Of this issue?
Yes.
Yes.
Okay. Thank you, ma'am. I appreciate you being here.
Ms. Latour?
I don't have any questions, Your Honor.
Thank you, ma'am. You may step down. We'll go ahead and take a mid-afternoon recess until 5 minutes till 4. Ladies and gentlemen, if you'll recall the instructions I've given you, leave your notepads in the chairs, gathering the deliberation over 5 minutes till 4. Everyone else, please remain seated while the jurors excuse themselves. Anything we need to take up before we recess?
Not right this moment, Your Honor.
There you are.
Be in recess till, what did I say?